If you're an injury attorney or working with a mass tort firm and your client just died, or you're trying to prosecute an action on behalf of a deceased client, then this video is crucial for you to understand your next steps. So today we're covering exactly what you need to do to preserve the value of your client's case and protect the deceased client's interests. Hi, my name is Dan Schnurbush. I'm an estate and probate attorney out of St. Charles, Missouri. So some of the first things you need to do, you need to notify the court in your pending personal injury case. There may need to be a substitution of parties once the personal representative is appointed. Definitely notify opposing counsel and make sure that they can give you some leeway in terms of getting this substitution taken care of as quickly as you can. If there are insurance people that need to be notified about the death, make sure that that's taken care of. Consider strategically whether it is a good idea to interact with the insurance parties at this time or not. It's important to understand that there is some urgency to this, right? So if your client died, we need to make sure that you've got evidence sufficient to support your claim in some kind of form that you can then use to continue to prosecute the case. And you don't want to lose momentum just because your client died. So it's important to understand generally how this legal framework works. First of all, when a client dies, if the death is unrelated to your personal injury claim, like suppose that they got in a car accident and then, a year later they die of heart disease or something. In that case, the car accident is clearly unrelated to the death. And in that kind of context, the injury action in the state of Missouri survives to the estate of the deceased person. Specifically, it survives to the personal representative of the estate of the deceased person. And this happens under section 537.020. All right. Now, this is different from wrongful death actions, which you might be more familiar with. And that's because in a wrongful death action, the accusation against the defendant is that the injury complained of is actually what caused the death. And it's important to understand in Missouri is that these kinds of claims in Missouri are actually independent actions under the Missouri Wrongful Death Act by the Class 1, Class 2, whatever they are, heirs in your particular case. So you'll need to refer to the Wrongful Death Act to determine how those kind of cases need to be prosecuted. But it's important to understand that generally in those cases, an estate does not need to be opened because there may or may not be any claims by the estate. Now, there still might be claims by the estate if there are claims of injury that predate or are unrelated to the death, or if there are claims for property damage or other things that may or may not fit into the wrongful death claim in the Wrongful Death Act. It can still make sense in some circumstances to go ahead and have an estate opened. When you're doing this, one of the first things you're going to need to do is figure out who could be a potential representative. It's not necessarily your job to make a final determination on who qualifies, but generally speaking, you should start to try and figure out who to even talk to. Now that your client is dead, who can you even talk to? Would it be a spouse? Would it be adult children? If none of those, would it be siblings? And that's kind of the order of the priority in the probate code, is that spouses have generally superior priority. And if a spouse isn't around, it goes to children. If kids aren't around, it could be grandchildren. If they're adults, and if nobody is a descendant, it can go out to collateral heirs. So if your client dies, start looking for those folks, kids, spouse, so on. Once you have this person identified, it's probably a good idea to quickly connect with a probate attorney and get that person in touch with them so that they can get the process started of opening the probate estate. In a perfect world, this should be done within less than a year of death. Presumably, you're wanting to make sure that your case continues apace and that you can get it to settlement or trial fairly quickly. So that being the case, you are probably going to want to do this sooner rather than later, as soon as you can. That way there's not going to be any hiccups or slowdowns due to the fact that your client passed away. But another thing that this emphasizes and underscores is the importance of making sure that you're doing a good job preserving your evidence, if that's in the form of affidavits, sworn statements, depositions, other kinds of material that can be used to preserve client's testimony or their client's evidence in support of their claim. So make sure that you have a good grasp on what to do and consider making that a part of your basic process, is making sure that your evidence is preserved so that if something does happen to your client and you do have to prosecute on behalf of a dead person, that you actually can support the claims that you're making against the defendant. Now, it's important to understand there can be delays in terms of getting probate appointments, getting somebody who's authorized to serve, so it's better to go ahead and get that started earlier, especially if we see things like disputes among the heirs, insurance problems, statute of limitations issues. So it's generally a good idea to go ahead and get that going, as I've said, as soon as possible. So if your client has passed away, make sure that you get in touch with a probate attorney, because it is possible to save that case. You don't have to abandon it. If you're a car accident attorney or just a slip and fall or whatever it is, if you're doing any kind of personal injury, if your client dies, be sure to get in touch with a personal injury attorney right away, and we can get that estate open. Now, on the other hand, if you are working with a mass tort firm and your client has maybe been dead for a long time, or the person on whose behalf you're filing the claim, maybe they've been dead for years, we can help with those kind of cases too. We've seen a lot of these with, things like the Camp-Lejeune Act, with Roundup cases, Risperdal, all kinds of these toxic exposure cases. In most cases, we see the defendant wants to see a representative appointed before they will pay out any kind of money. And fortunately, there are a couple of different ways to handle this. We can just file for a traditional application for letters. Sometimes we can apply for a determination of heirship or other situation if we have a check that's pending. And in extreme cases like the Camp-Lejeune Act, where we need to have somebody appointed, we can rely on certain kinds of statutes or attempt to rely on statutes such as 537.021 that lets us file beyond the 1-year filing deadline in some cases. All right. So that's what I want you to take away for today, is that it's important to get started and act fast early if your client dies or if you need to prosecute on behalf of a deceased client. So if you want to learn more about probate, check out some of our other videos or give us a call. This is Dan Schnurbush. Talk to you guys next time.